Procedure in the Supreme Court. Rule 56. A. Original cases. Section 1. Original cases cognizable. Only petitions for certiorari, prohibition, mandamus, quo warranto, habeas corpus, disciplinary proceedings against members of the judiciary and attorneys, and cases affecting ambassadors, other public ministers and consuls may be filed originally in the Supreme Court. N. Section 2. Rules applicable. The procedure in original cases for certiorari, prohibition, mandamus, quo warranto and habeas corpus shall be in accordance with the applicable provisions of the Constitution, laws, and rules 46, 48, 49, 51, 52 and this rule, subject to the following provisions. All references in said rules to the Court of Appeals shall be understood to also apply to the Supreme Court. The portions of said rules dealing strictly with and specifically intended for appealed cases in the Court of Appeals shall not be applicable, and 18. Clearly legible copies of the petition shall be filed, together with proof of service on all adverse parties. The proceedings for disciplinary action against members of the judiciary shall be governed by the laws and rules prescribed therefor, and those against attorneys by Rules 139b, as amended. N. B. Appealed cases. Section 3. Mode of appeal. An appeal to the Supreme Court may be taken only by a petition for review on certiorari, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment. N. Section 4. Procedure. The appeal shall be governed by and disposed of in accordance with the applicable provisions of the Constitution, laws, Rules 45, 48, Sections 1, 2, and 5 to 11 of Rule 51, 52, and this rule. N. Section 5. Grounds for dismissal of appeal. The appeal may be dismissed motu proprio or on motion of the respondent on the following grounds. Failure to take the appeal within the reglementary period. Lack of merit in the petition. Failure to pay the requisite docket fee and other lawful fees or to make a deposit for costs. Failure to comply with the requirements regarding proof of service and contents of and the documents which should accompany the petition. Failure to comply with any circular, directive or order of the Supreme Court without justifiable cause. Error in the choice or mode of appeal, and the fact that the case is not appealable to the Supreme Court. N. Section 6. Disposition of improper appeal. Except as provided in Section 3, Rule 122 regarding appeals in criminal cases where the penalty imposed is death, reclusion perpetua or life imprisonment, an appeal taken to the Supreme Court by notice of appeal shall be dismissed.
Gcash is a domestic online application which is the best app to use when paying bills. You can also invest in the stock market using this app and an app to buy life insurance. Try it now. See the link in the description of this video to get 50 pesos cash rebate.
An appeal by certiorari taken to the Supreme Court from the regional trial court submitting issues of fact may be referred to the Court of Appeals for decision or appropriate action. The determination of the Supreme Court on whether or not issues of fact are involved shall be final. N. Section 7. Procedure if opinion is equally divided. Where the court and bench is equally divided in opinion, or the necessary majority cannot be had, the case shall again be deliberated on, and if after such deliberation no decision is reached, the original action commenced in the court shall be dismissed. In appealed cases, the judgment or order appealed from shall stand affirmed, and on all incidental matters, the petition or motion shall be denied.